morning, everyone. It is now 10 a.m. We are going to go ahead and begin our Amending Governing Documents webinar. A couple housekeeping items is to avoid disruptions, all participants will be muted and the ability to join with video will be disabled since this is a webinar type of video. At the end of this webinar, we will be receiving a copy of the presentation along with the PowerPoint if you attended the webinar. At the end of this course, the presenters will go ahead and take questions and answer anything that they are able to answer in whichever way possible. On behalf of Vesta Property Services and Raphael Law, we welcome you and thank you for being here with us today. And we're going to go ahead and get started.
Hello, everybody. My name is Jill Koch. I am the General Manager for the South Florida, Fort Lauderdale, Hollywood region for Vesta Property Management. Our current property intake at Fort Lauderdale, Hollywood is 56 properties. I joined Vesta in December, where I was acquired and I was formerly known as JK Property Management. It is a pleasure to be here and to teach you all the fun, wonderful things about reading your condo and HOA documents and amending them.
Good morning, everyone. My name is Lindsay Raphael. I am the founder, president of Raphael Law, PA. I was previously a partner at Chip Scott, where I was for 17 years, and then briefly at a local association firm for a year and a half. And then most recently, about a year and a half ago, I decided to finally take the leap and go out on my own, which has been amazing. I'm really excited to have all of you here today. I actually love amending governing documents. For me, it's fun. For boards and managers, I know it can be a very stressful process. So we're here today to, it's going to be a lot of, specific information. But I think the most important thing to remember is, as a manager, you don't need to memorize and know all of this. What you really need to know is when it comes to amendments, do not try to do them on your own. You have to call the association attorney. Even drafting them is considered the practice of law. So if any managers or board members are actually drafting amendments to documents and then record them, that is actually considered the unlicensed practice of law. I know that I'm usually the last person that people like to call, but when it comes to amending documents, it is important that you involve the association's attorney. So let's just, if it's okay, Jill, I'm just going to kind of dive right in and talk about what's considered the governing documents of the association. And please excuse me, I have a bit of a cold, so that's why I sound like this. So a lot of people, when they're referring to association documents, just call them bylaws. Oh, that's not what our bylaws say, or here are our bylaws. Bylaw is a very specific document. There are actually 4 types of documents that make up the documents of an association. You have your declaration, which I call your Bible. It is the constitution of the association. That is where you are going to find all your use restrictions. It's going to describe the units. It's going to describe percentage of assessments. It's going to have your sketches, your plots. Essentially, it is where all the authority and the documents is in your declaration. That's where you're going to find your leasing restrictions, whether you can have commercial vehicles, animals. It's going to talk about how you impose assessments, whether you're allowed to have special assessments, material alterations, who's responsible for maintenance. That is your meat and potatoes. Then you have your bylaws. And your bylaws, unlike the declaration, which is how the association itself operates, your bylaw is how your board operates. It's what tells the board how much notice they have to give when they're having meetings, what has to be included in the notice. It will touch upon some budgetary and financial notice type stuff. It will tell you how many people have to be on the board, how you figure out how many people are on the board, the powers of the association. So that's where how the board itself manages is dictated. And then you have your articles of incorporation, which is what actually makes your association a corporation. Interesting is that before 1977, associations did have to be incorporated. So you may see, if you are an older association and you're looking through your governing documents, you may find that that particular association isn't incorporated, and that is why. But after January 1, 1977, all associations have to be incorporated. So what's in your articles of incorporation is your corporate name, the office, where the principal office is, mailing address, registered agent, who's incorporating. It's typically a much more simple document. You do have to be careful though when amending bylaws though. Anytime you're amending documents, I want to say this so that I don't forget, it's important that you look at all of the documents, okay? Because you could change something. Let's just take your bylaws, for example. Let's say you want to increase your board from 5 to 7, or we'll say 3 to 5, okay? You also have to look at your articles, because your articles sometimes will mirror the language that's in the bylaws, and will also have how many people sit on the board. So if you have that language in both your bylaws and your articles, you need to make sure you're amending it in both places. That's just one example, but the same if you're, removing a power, so you need to be looking at all the documents when doing amendments to make sure that whatever you're adding or changing isn't conflicting with another document. And then you have your rules and regulations, and your rules and regulations are documents that typically are allowed to be amended just by a board vote. Okay. Your other 3 documents, your declaration, your bylaws, and your articles, require a membership owner vote. But rules and regulations, unless your documents require a membership vote, is just the board. And typically, the board is allowed to make rules regarding common elements, clarifying ambiguities, but you cannot create any rules that conflict with the declaration, the bylaws, and the article. And so it's common elements, clarifying any ambiguities, and if the documents specifically allow the board to make a rule and regulation. An example there is, let's say you have a leasing approval process. And in that process, in the declaration, it says that the board is allowed to make rules and regulations regarding factors that they could consider. Then you would have the right to make a rule and regulation without a unit owner vote, because the declaration specifically gave you the power to make that rule. Other than that, most changes should be done in the declaration. What you cannot do is you cannot say, we all of a sudden want to have a sale or a lease approval process. We don't have one. We want to be able to deny people. We're going to create that in a rule to avoid the unit owner vote. Can't do that. That has to be in your declaration, okay? And one more thing about rules and regulations. Typically, while that is a standard board meeting, you still have to look at your bylaws to see the type of notice requirements. If your rule is going to affect parcel use in any way, the statute requires a 14-day mail notice, okay? That is in both the condo statute and the HOA Act. So if you're
Lindsay,
ever talking...
Sorry, go ahead.
If you're ever talking about assessments, or you're ever amending documents having to do with the use of a unit or a parcel, that is always a 14-day mailed notice unless the documents have a stricter notice requirement.
Is there a particular order that the governing documents have to be in order for impact? Like, does one have to be ahead of the other?
So your declaration of condominium if there's a conflict, your declaration controls. Like I said, that is the constitution of the association. You also cannot be creating amendments that conflict with the declaration. You cannot use association rules and regulations to expand the board's authority more than the declaration gives. But typically, if there's a conflict, it goes declaration, articles, bylaws, and then you have the association's rules.
Thank you. And then what happens if your association documents are missing? How can you find them?
So, well, let's hope they're not missing, because I do want to remind everyone that you are required to keep these documents on record forever. But if they are missing, one way that I go about looking them is I can they are public records. Okay, so you can search the county that you're in, the clerk of courts. It's not, I don't want to say it's a difficult process, but you're going to have a very hard time knowing if you found everything. Okay. The best way to do it, and how I do it, especially, when I have a new client or if we have any doubt that we have all the documents, is I run a title search through the underwriter. And so that we can rely on that, and they can find and pull everything recorded against the governing documents. And if you are an HOA and you are ever doing a preservation of your documents or a revitalization, I do not care if you and your attorney say that you have every single document, you better run that title search, because if you have a problem and one document doesn't get recorded, you want to at least be able to say that you did the best search possible and you're relying on the title underwriter.
Perfect. Thank you.
Okay. Next, so your process for amending documents. I may speak a little out of order here, but the first thing is obviously you got to decide, what you're trying to amend, because that's going to dictate whether you're amending your declaration, your bylaws, your articles, your rules. This is really where the attorney comes in, because you may not know what the appropriate document is for the rule that you're trying to do. 718 and Chapter 720 of the Florida statutes will have language in there about amendments. Amendments to these documents, especially the declaration, do require a unit owner vote. What that vote requirement is depends. It can be a majority. It can be a majority of those in attendance at the meeting. It can be 66 2/3. It can be 75%. I've even seen 80%. So you have to look at your specific documents. There is default language in the statute. If your documents are silent, I want to say, I think it's like 2/3 or something. But either way, you start with your documents, and if your documents don't have a percentage, then you turn to the statute to see what your vote requirement is. Then you want to, like I said, you want to identify what sections of the documents or what changes that you're wishing to amend. Then, you can have a committee, or the board along with management can kind of do a draft, or at least a bullet point of, I usually like to say this: you should start with whatever issues are going on in your association. Okay. I get calls all the time. Oh, our association's from 1980. We have to change all of the documents to bring them up to date. No, you don't. No, you don't. And I don't mean to be rude, but any attorney that tells you that you did is just because the attorney makes more money. You're not required to do that. In your particular association, depending on how your documents are written, it might be a good idea, but I've never recommended to an association of mine that just because your developer isn't there anymore, go ahead and take out all the developer language. Why? You know how time consuming that is for the attorney to go through and take all of that out? Again, it's a project where the attorney's making a lot of money, but it really isn't going to change the effectiveness of your documents. Where I say to start is, what's going on in your association? Are you having a parking issue? Are you having issues with your approval process? Are you having issues with the type of renters that you're getting in there? Are you having issues with pets? Those are typically the kind of amendments that I see a lot. Do you have a really high amendment requirement? Sometimes the association wants to amend the documents to reduce the amendment vote that they need. If that's the case, you will need that high vote requirement to change it. But, in that case, typically we would just put that one amendment to vote. And then if it passes, all the other amendments you want to do, we would do after at the lower percentage. So that's where I typically say to start. I don't think you don't have to sit there and write it out word for word what you want, but usually it's helpful to me if I get some kind of bullet point list that these are the issues we're having. This is what we would like to prevent or allow. And then I take that and I then draft language for the board or the committee, whoever it's going to be, to review to see if it's in line with what you're trying to accomplish. When I get an amendment project, what I go through is what's the proper procedure for amending your documents. Do not expect that just because you've had an attorney for 10 years and they've read your documents a bunch of times, that this is something that they're ever going to remember off the top of their head. We pick up documents all day long. I mean, I have 200 association documents. Your attorney is always going to need to go to refer to your documents, especially if you have a specific question about anything that's in the documents. No one, even if they think they know it off the top of their head, you have to be accurate. So you always have to go and reference the documents. So I will consider the proper procedure for amending documents, which document needs to be amended, what the vote requirement is for it to pass. Then what are the notice requirements? Is it a 14-day notice? Is it a 30-day notice? Is this going to be a special meeting, a regular meeting? And then the manner in which the voting takes place. I will tell you that 9 out of 10 associations call a membership meeting, and the owners will go to the meeting and vote or fill out a limited proxy, and then the proxy holder goes to the meeting and vote. But there are times, especially during COVID, that we saw that you can, depending on your association documents, sometimes you can also do it in a written agreement outside of a meeting. And what that is you have the package. So you have kind of a certificate that the owners will fill out about how they want to vote, along with the proposed amendments, and then they need to mail it back or hand it back to the association within a certain time period. And so then you're taking the vote by mail, essentially, instead of attending a meeting. There's good and bad with that. Some associations some boards have probably been able to get more votes doing it in person, because if people have questions, you're able to explain the questions. You have to, only your audience. So that's a question you'll have to decide at that point. But most people do it at a membership meeting. And you also can do it electronically, but electronic voting is a whole nother conversation. Again, there's good and bad with electronic voting. Even if you do electronic voting, you're never going to get 100% electronic votes. There will always be people that opt out. Personally, in my mind, sometimes the process can become even more difficult, because now you're counting your electronic votes and your paper votes, but to each his own. Every association is different, and some associations just have so many people out of town that the electronic voting works better for them.
So, Lindsay, do you recommend that board members start? I know we discussed this beforehand, but we have a lot of new people. And do you recommend board members starting to do strikeouts and do amendments, or do you recommend them going through and giving you a to-do list and you making the recommendations and the corrections first? What is the best process for doing that?
Well, I mean, they're not going to be able to fully strike anything out, because like I said, ultimately, the attorney is going to have to draft what the amendment is going to be. I don't personally have a problem if they want to go through and start marking stuff up for me to read. It doesn't mean I'm going to agree. If I don't agree, I'll send an email or get on a call with the client to explain why I don't think that should be amended or removed. But ultimately, they can do whatever they want, because it's not going to be enforceable until it gets recorded. So really, they're just going through an exercise process. Obviously, the more information that they can give me so that I really know what it is that they want changed is helpful. But most people will just say, I always like to take leasing, because every association has leasing issues. We want to be able to approve or deny and run background checks, and we want to have factors to consider. Can you put together a leasing restriction for us? And then for me, I go and I'll do what I like to consider my general leasing restriction. I will put everything and anything in there that is typical, that most associations like, and then I'll submit it to the board, and they can say, no, we don't want to have that. Yes, we like this. No, we'd like to have, instead of 20 days, we'd like to have 30 days. And that's generally how the process works. And by the way, sometimes I just get an email that says, we want a leasing process, we want a sale process, and I don't get anything other than that. And again, I'll go and I'll do it based on what a typical procedure is in most association documents, and then we go from there.
Now, what happens if they want to amend something where it's different from state statute? I'll give you an example. State statute says, I believe, I'm not interpreting, I believe state statute says that late fees are $25 or 5%. What if an association wants to amend their late fees to say $200? Can they
Nope.
do that? And if they were, they can't do that.
No.
Okay.
When it comes to late fees, you have your statutory amount. And something really interesting about late fees, with a lot of associations don't know, you're only actually allowed to charge late fees if your documents allow you to. If your documents are silent, you can't charge late fees. It's the opposite with interest. Interest you can charge even if your documents are silent, because the statute mandates that you can, but your interest requirement, like your interest amount, is based on what your documents say. So I'll see like a lot of documents that were drafted in the 80s will be at like around 10%, but today you can charge up to 18%, but only if your documents allow you to. If your documents say 10%, you're bound by the 10%, even though it's not the highest rate allowed by law.
Now, what happens if the amendment will go with fining, right? So the state statute, I believe, says $100 a day up to $1,000. What happens if you want to amend your documents for $100 a day, no, like reoccurring, there's no stop to it? What supersedes that? Does the state supersede, or does the new document supersede?
Well, what do you mean? I don't
Like there's no, so the state statute, you can confirm, is $100 a day up to $1,000 per occurrence.
Yeah, it's $100 a day up to, I think it's like 10 days up to $1,000. And depending if it's a condo and if it's an HOA, if it's a condo, you're capped at $1,000.
What if you change your documents saying that there's no cap?
So in a condo, you can't. That statute controls you. You're capped at $1,000. Now, every $100, every violation can be considered a new violation or continuing violation. We obviously look at that on a case-by-case basis. In an HOA, it's different. It's $1,000 unless your documents allow you to fine more than $1,000. And in an HOA, any fine over $1,000 can also be liened and foreclosed on.
So if you're, I guess I like went off on my question here, but if you amend your documents to say one thing and the state says another thing, what supersedes?
So that depends. And I know that no one likes to hear that. So we'll take the fining, for example. And it all depends on how the statute is written. If the statute is a shall, and it says the association, shall charge or can only charge or something like that, the statute trumps. If it's a default or recommended, sometimes the documents control. So it all depends on what it is. When it comes to fines, and let's just take the $100 a day, okay? And let me see, maybe I could even pull up an example here. Actually, I have the statute here. Let's say you're $100 a day. You can't then change it and decide that you are going to charge $150 a day instead of $100 a day, just because your documents state that you can charge $150 a day, because your statute doesn't let you charge more than $100 a day. So that's one of those cases where the statute is going to control. Another example of that, and I was just trying to look in here really quick to see if I can pick up the fining language. Another similar thing like that is if your documents have a different fining process. Like the statutes were changed a few years ago. It used to be that the boards didn't impose fines at all, only the committee did, but that's not the way it's written anymore. Now it's a two-step approach. The board actually imposes a fine, and then the owner's supposed to get 14 days notice after that, where the committee either agrees to accept or reject the fine. If there's a different procedure in the documents, the statute controls. Now, you may have a more stricter approach, and depending on what it is, that may control, but that's all a case-by-case basis. Like I wouldn't even be able to give a exact answer on that, because it all depends on what's in the documents, because sometimes the documents control, sometimes the statute controls. It depends on what it is.
Okay.
Now I'll give you an example of going back to your late fees. So the way the HOA section reads, if the declaration or bylaws so provide, the association may also charge an administrative late fee not to exceed the greater of $25 or 5% of the amount of each installment that's paid past the date. You see that language. It's not a may. It is if you are allowed to charge it in your documents, it cannot exceed that amount. Could it be less? Could you have a $10 late fee? Sure. But you can't have more than 25 or 5% of the installment.
Okay. Thank you.
You're welcome. Okay, what's next? Okay, so let's fast forward. I've now prepared for you the greatest set of amendments that you've ever seen in your entire life. And now it's, what do we do with them? As part of my package, what I do for my clients is I do the proposed amendment, and then I do the membership meeting notice, the limited proxy. So you get everything from me. When it is all said and done, and after the board approves it, and we have a final set of documents, you will get a whole package for me, and Jill can attest to this, that I'm going to say, this is exactly what you need to mail to the owners. Again, all of that's dictated by, what your bylaws state. Now, assuming the vote passes at the meeting or through your written agreement, however you take it, the amendments are not enforceable until recorded. So they do have to be recorded. That means the association needs to return to the attorney the certificate of amendment, which gets executed the same as a deed. So it's 2 witness signatures. Sometimes it's just the president's vote. Sometimes it's 2 officer votes with witnesses and being notarized. And that gets recorded on the top of the amendment. I then change it from proposed amendments to amendments. If some amendments pass and some don't, I'll go through and I'll take out the ones that don't pass, and then we record it. Once I get back the recording information, I'll then send it to Jill or whoever the property manager is, and then they get sent out to everyone in the association with like a little letter saying, please keep this with your other with the association's governing documents.
So what about rules and regulations? The board, we said earlier that the board votes on rules and regulations. How do those get processed? Do they get registered with the county, or do they have to be recorded?
So a few years ago, and personally, I don't know why the legislature did this, because it honestly doesn't make sense, because rules and regulations can change with different boards. You could have one rule this year and next year a new board can come in and change it. But they amended the definition of governing documents to include rules and regulations, and the statute says all governing documents need to be recorded. So I believe at least now in the HOA setting, even your rules and regulations have to be recorded.
Thank you.
Hopefully that will change.
I don't think it's necessarily a bad idea.
I mean,
when you're doing a title search, it makes sense that they're all together.
Yeah, it does.
Okay, go ahead into text. I have more questions for you in text.
Yeah, I mean, this is just very specific. The statute has a procedure. It says any new words that you're including have to be underlined. I underline and I bold. Any words that are deleted, have to have a line through them. It says hyphens. I do mine with a straight line. But then you get into, if the proposed change is so extensive that you really wouldn't even be able to read it because of all of the underlines and all of the deletions. Typically, we call that amended and restated documents. If you're doing an amended and restated documents and you are changing so much that it's like, it doesn't even make sense to do the underlines, and you're not required to show the changes. However, I have very few associations that do that. Most clients want the owner, or let me say this, I don't know that most boards want the owners to see all the changes, but most owners want to see all the changes before they vote on it. So a lot of times the package that will still get mailed out may have the underlines and the hyphens going through so that the owners can see what's being changed. Are you required to do that? No, but you may have some owners that decide not to vote on it. Or you may have owners that are more likely to vote on it if they don't. But again, that's about knowing your audience. And Amended and restated documents are extremely expensive. Know that is not a couple $1,000 project. Essentially what you're doing is you're also taking every amendment ever done, to the extent that you want those amendments to continue to be part of the documents. Those also have to go in, and you're cleaning everything up, and then you get a new set of documents that essentially is filed on the public records. You said you had some questions.
I'll go as we.
Oh, okay.
Okay.
Okay. So this relates back to what we were talking about, the unit owner vote that's required, or parcel owner vote, when you're making amendments. 718 has had this language, the condo statute, for a while. And I'm just gonna read it because it is very specific. Essentially what it says is that unless otherwise provided in the governing documents as is originally drafted, okay, so that means the developer's documents, no amendment may change the configuration or size of any condominium unit in any material way, nor may it materially change the appurtenances to that unit or the percentage of each owner's share of the common expenses and common surplus, unless, and I'm going to sum this up, it's 100% unit owner vote. Okay, that's it. You want to let's say that you happen to be an association that splits assessments equally. Let's say you have 20 units and it's 1/20th to everyone straight down the middle. You cannot say, you know what, we don't really think that's fair because a couple of the penthouse units are bigger, so they should pay more. So we're going to do it based on percentages of square footage. Nope, that's 100% unit owner vote, which you will never get. And not only that, it's 100%, it requires lender vote too. So it's not even just the owners, okay? The HOA Act has very similar language that says that you can't materially or adversely alter the proportionate voting interest pertinent to a parcel or increase the proportion or percentage by which a parcel shares in the common expenses of the association, unless the record parcel owner or all record owners of liens on the parcel, so that would pretty much be your lenders, join in the execution of the amendment. I'm sorry, I see some typos here, which we'll clean up before this goes out to everyone. So those are prohibited amendments that I don't care what your documents say. It might say you only need a 50% unit owner vote. When it comes to those kinds of changes, you are limited, and it's 100% unit owner vote. Okay. And by the way, where it talks about nor may it materially change the appurtenances to that unit, that means that there's even like some changes with common elements you can't make. Like you can't decide that you have this like little game room with your association that's not used as a game room anymore, but there's a condo unit right next to it, and they want to blow through that wall and make their condo bigger and take away that portion of the common elements. By the way, I've seen this happen. I've seen it happen with rooftop units where there's a little common area on the outside, like a balcony that no one uses, and this owner wants to buy it from the association and use it as their own rooftop area, which seems pretty innocent. The association is going to make money. It's not something that gets used. No, but it's a common element, and it's pertinent to every unit in there, whether it's used or not. You cannot commandeer a portion of the common element for one person's use without 100% unit owner vote. Okay. So let's go to the next.
Lindsay, what happens if you don't get 100% vote?
It doesn't pass. You can't change it.
Okay.
Now, I won't get into the specifics of this, but there were changes to the statute years ago. Oh my God, maybe it's like 7 years ago now, 5 years ago, that tell you exactly how you have to put the lender on notice, because I think the legislature realized like it's like impossible to get a hold of the lender. Like forget about it. They're never signing anything. They're not agreeing to anything. But there are certain notice requirements that if you put them on notice, they're approved. You're deemed to get their approval. I think if like they don't respond, that's a statute that's in the document. But the hardest part is you're always going to have one person that says no. I mean, I've never seen an association get 100% unit owner vote. It's nearly impossible. Maybe if you have a small association.
We remember a while ago back, we had an association that wanted to go from a pro rata share to an equal proportion for their association fees. And it was very hard. We actually did not get unit owner vote. It was very hard to convince the homeowners for that. So it's something that everyone should really look at too, if this is really what they want.
Especially if you're the biggest unit owner, like,
correct.
You'd be dumb. Why would you agree on that? Now you're increasing. I actually had the same thing happen in my association. I live in an HOA because apparently I'm a crazy person, like probably all of you. And there are owners in there that are upset that it's equal. And it's funny because it's not Vesta, unfortunately, who is running that association. But you can imagine what
we should change that.
I would love to change that, but
we should change that.
I decided with this particular association, I'm not willing to sit on the board despite continuing to get asked. So instead, you can imagine what a pain I am because my board doesn't run the association properly. And the manager has no idea what she's doing. So I go to these meetings, and they had a meeting, and someone raised that, and there's a big difference between the size limitations of the townhomes. I mean, like the smallest one could be like, I don't know, 800, almost like the size of a condo, with the biggest being 3,000 square feet. And the way the documents were drafted is I think there's like 150 units. So it's split equally. So they have this whole meeting about how that's fine. We'll go ahead. We'll change the documents. We'll do it on percentages. Manager's like, sure, I'll go ahead and draft it. And I'm like, you can't do that. They're like, why can't we do that? Well, because you can't change the percentage of what I pay in my common expenses without 100% unit owner vote. Not one person at the meeting believed me. I had to go and pull the statute and send it to the manager. And guess what? I'm never voting yes for that because I have the biggest unit. So why would I vote yes for that? You'll never get 100%.
Right.
Well, I should not say never. I'm sure that there are circumstances where people do, but I would tell you, I would not waste the association's money or your time if you realistically don't think you can get it. And by the way, I think that that's important for a lot of amendments. Sometimes, you might have to go through the actions of trying to do the amendment just because it's the right thing to do for the association and to show that as a board, you're making good decisions. But in general, if you know you can't get that vote, don't waste the time because amendments aren't cheap. I mean, you're probably looking, depending on what it is, somewhere between $700 and it could go up to $20,000. You're doing a full amended and restated document and you have 200 and something pages to your documents and lots of amendments. The project can be very expensive. So, you definitely want to have an idea if you think you can get it passed before embarking on a project like that.
So sometimes it might not be a bad idea to ask your homeowners if it's something that they're interested in before going through the process.
Yeah, I would say, especially if you're doing amended and restated documents, because, that's where it gets really expensive. I mean, you have to retype all of the documents. And I know people say like, oh, but you can have it on a PDF and then you just transfer it. Yeah, but every other word is wrong. So it is actually more expensive for me to go on an Adobe PDF and turn it into a Word document and then catch that every other letter is a 4 or a $sign and make those little changes than it is for me to retype the whole document. And then you have to pull all the amendments and you got to put those in all the right places. And if you've had the same provision amended 10 times over the last 20 years, you got to go through and make sure you have the most up-to-date one. And it's a long process, plus changing whatever it is that they want to change. What I tell my associations is if you think that you're going to get pushback at that meeting and you're not going to get the vote, then it may make sense to have a community after we do the amendments, to have like a community meeting where you allow the owners to kind of look at it first and give their feedback, because at that point I can make changes to the documents Once the document goes in the mail with the notice of the meeting, any change, even if it's a slight change, you have to start from scratch. You can't just make the change at that meeting and then get the vote.
Right.
So, I would say if you think that if you're in an association where the owners are very vocal and you don't think you're going to get the vote without their input, then, sometimes we go ahead, we prepare the changes and then you send it out, or you could even form a committee to work alongside the board to help with suggested changes.
Well, let's talk about the new laws, so that way we can get to a lot of our guests' questions, because I know that changing association documents is very sexy. So let's get to their questions.
So there are two new laws. One is affecting an HOA and one is affecting a condo. This is just, let me take that back. There are a ton of new laws that came out July 1st, like substantial. The statutes have been, the assessment portion of the statute, there have been a lot of changes. We're not going to get into that today. We certainly could do a legal update in another time, but these changes apply to amendments to documents, which is why I pulled them out. And so the first one, we're just going to say the one affecting the HOA says, except as otherwise provided in this paragraph, any governing document or amendment to a governing document that is enacted after July 1st, 2021, and that prohibits or regulates rental agreements applies only to a parcel owner who acquires title to the parcel after the effective date of the amendment, or to parcel owners who consent individually, okay, or through a representative. So what this is saying is, if you're going to have any changes regarding rentals, okay, that either it doesn't allow rentals or changes what your documents are regarding rentals, the person has to vote yes to it in order for it to apply to that person, or it has to be a new owner who buys after the document has been amended and actually recorded in the governing documents. So that doesn't mean it might not pass. But Jill, we actually have this in one of your associations. I won't say which association it is, but there's one man, it's a very small condo, and because this applies to condos too, who voted no on these rental restrictions, and everyone else voted yes. And it drives everyone crazy because this person can continue to rent even though it's become a no rental building. And everyone who voted yes has to comply with it. Then there is an exception to this, and it says, notwithstanding subparagraph 1, an association may amend its governing documents to prohibit or regulate rental agreements for a term of less than 6 months, and may prohibit the rental of a parcel for more than 3 times in a calendar year, and such amendments apply to all owners. So if your change is going to be saying that someone can, only rent 6 months or less, that's not going to require a unit owner vote. Or if you're an association that's going to say that it can't be for a term of less than 6 months, that's not going to require only those individuals to consent. Or you actually can amend it saying that you can't rent more than 3 times in a year, and it'll apply to everyone, not just the people that vote for it. Now, the Condo Act has similar language. This is actually not a new law. The Condo Act restriction is actually, I don't know, maybe about 7 years back. So the HOA one was amended to be brought up to date to be very similar to the condo statute. When that says is rental restrictions, which must be approved by the owners. So an amendment prohibiting a unit owner from renting their unit or altering the duration of the rental term, or specifying or limiting the number of times unit owners are entitled to rent their units during a specified period, applies only to unit owners who consent to the amendment or acquire title after the effective date. So again, and I apologize for any spelling errors, I'll correct all of that before it goes out. But this is very specific. If you are making any changes to the documents that fit into those 3 or 4 restrictions, it only applies to those who consent or new owners going forward. Owners are allowed to abstain from voting, with the exception of the HOA and condo law that we just talked about. Just because you abstain does not mean it doesn't apply to you. That's only going to apply to these rental restrictions we talked about. In general, if someone just doesn't vote and an amendment passes, it applies to everyone. But it doesn't apply until the amendments are recorded. If the association doesn't get the required vote for these amendments, there's no amendment. The documents as of that date stand the way they are.
Thank you, Lindsay.
You're welcome.
So, couple questions from our guest. Number one, where do covenants fit? I assume they would be part of the declaration.
So your covenants are, so your declaration is also referred to restrictive covenants. They're one and the same. It's called a declaration, but those are your restrictive covenants.
Is the hierarchy of mandates to order that you need to follow? Can rules and regulations conflict with Florida statutes? I think that's two questions.
Your rules and regulations can't conflict with the statute, and it can't conflict with the other documents. So let's say, for example, let's say that you live in a building that allows pets. You can't create a rule that says no pets allowed.
Right.
You know, you can't have declarations that are silent about commercial vehicles and then create a rule that says no commercial vehicles allowed.
So that's the whole thing. We haven't touched about rules and regulations though, but that's the whole thing that board members and homeowners should know, and property managers should know, that rules and regulations cannot conflict with your documents. So a board cannot make a rule of the community that conflicts with a common area or your rules and regulations. So they can't say, we are no longer using the pool in the rules and regulations, because that changes common element, correct?
So the 3 times you're allowed to make rules is if it affects the common elements, if you're clarifying an ambiguity, or if your other governing documents such as the bylaws or the declaration give you specific authority to do so. Okay, those are the 3 times that you're allowed to make rules. So the first one, I just lost my train of thought. So to clarify an ambiguity, if your documents allow you to in the common elements, let's talk about common elements. In general, the board, unless the documents say otherwise, is allowed to make rules and regulations regarding the common elements. However, you cannot create a rule that is not consistent with your declaration. So let's say your rules say that, let's say your declaration, okay, you have a pool, okay? You can make rules and regulations that have pool hours, that have pool rules, okay? Because it's the common area, and as long as what you are putting in your rules doesn't conflict. So let's say let's say the declaration says that the pool's open from 8 to 6, okay? That's in your declaration. You can't create a rule that says, no, we're gonna be open from 9 to 5, because that would conflict. But if your declaration is silent and it just, doesn't say anything, but you have a pool, you can create reasonable rules and regulations. And by the way, guys, it all comes down to reasonableness, okay? I don't care that your documents say that boards can make decisions in their sole discretion. Board members are always, you always have to be reasonable, okay? So the same would apply to rules and regulations regarding common elements. So there are times that you can just make rules about the common elements. You just have to make sure that what you're not doing is essentially, you can't use the rules to expand your authority to get to be able to do something that the declaration doesn't already allow you to do.
Perfect.
And then if it's a use restriction, it should really be done. Like if it's going to affect the use of the parcel, if it's going to affect the use of a condo, if you're changing anything in your use restrictions, like pets, cars, parking, for the most part, that has to be done in your declaration. But that doesn't mean that if you have some common element parking, that as long as it doesn't conflict with the declaration, that you can't have additional rules.
Okay, what about, what are the requirements to establish committees? For the board to establish committees? So
again, that depends on the documents. Usually that's in your bylaws. Some bylaws will say that the president has the authority to appoint committees. Some will say that it's a vote of the board. It just depends on that particular association. I will tell you that when you form these committees, they should be ad hoc committees. And when you do it, anytime you have board, it has to be done in a board meeting. But anytime you do it, you need to set up like what their power is going to be, what their authority is going to be. I like to recommend that it be an ad hoc committee that just gives advice to the board, that ultimately the board makes the final decision. And if the board at any time wants to dismantle the committee, that the board can do so. The committee should not have more power than the board.
Okay.
And by the way, there are specific rules with committees when it comes to financial stuff. I mean, I won't get into that, but you have to look at the statute because
Right.
I believe if it has anything to do with making decisions regarding the budget, there's different restrictions on those types of committees.
Perfect. Declaration, articles, bylaws, and amendments to them are recorded with county. Boards tend to often overstep rulemaking authority because rules and regulations are not recorded and do not require amendments. How can this be monitored?
Well, I think rules do require amendments. It might not require an amendment. I mean, anytime, if you have rules and regulations that were written by the developer, originally recorded, and you're changing that, it's an amendment. It might not be an amendment that requires a unit owner vote, and it may not be an amendment that the statute dictates, but it is still a change. It's an amendment. And rules now do have to be recorded, unfortunately, because the rules are defined as governing documents. The governing documents are required to be recorded.
Perfect.
But again, I will tell you that the best way to deal with this is you shouldn't be amending the rules, and you shouldn't be amending the documents without the attorney being involved. If the attorney is involved, then it should be done properly.
What are the most common updates needed for 20-year plus association?
That's a more difficult question because every association's documents are different. I would say that where I usually go to look, and again, it depends on that association. I mean, most changes that I see are pet restrictions. Obviously, with emotional support animals and service animals, it's very difficult these days to be a no pet building. So some associations might change that or might change what they allow to try to even, sorry, excuse me. Sorry. Leasing restrictions and sale restrictions. If you live in a community that doesn't currently allow you to have some kind of approval process, that's a lot of the changes that we see. I'd say in the last 10 years, you see a lot of changes that even if your documents allow a leasing or sale approval process, that there were no factors as to what the board could consider. Most original declarations from 20 years ago will not have anything like that. Today, most attorneys that draft that will have in there specific to felonies, specific to backgrounds. You have to have language in your documents that allow you to run a background check. You're not just allowed to run a background check on someone.
Right.
So that's a lot of the changes that I see. Commercial vehicles, I think some associations you're seeing a little more lax. Some vehicles these days that some people might consider to be commercial, they're not used for work. They're just beautiful pickup trucks. Some associations really hate pickup trucks no matter what they look like. I'd say some of the biggest changes is going to be interest rates for assessments, because a lot of the older documents had specific percentage rates that were low. The way I change that now is I say the highest percent allowed by law. That way, if that interest rate fluctuates over the next few years or next 30 years, you don't have to go and amend your documents every time. The same with late fees. If you have an association that either had low late fees or doesn't allow late fees, that is a change. Also, a change is going through your foreclosure process and your lien process. If there's any language in there, you'd be surprised. It's in a lot of older documents. It says that if a third party purchases the unit at the association's foreclosure sale, that third party is only liable for assessments going forward. That is absolutely something I would change. The benefit to a third party purchasing at a foreclosure sale is typically they're responsible for everything, including all past legal fees, whatever was in that final judgment amount. So that is absolutely something. And then another thing is that the statutes changed over the last 10 years as to how much banks owe. It used to be that it used to be silent. And then it used to be that they only owed 6 months of past due assessments. And then years ago, it was changed to 12 months. I would change that to, say whatever the greatest amount they're obligated for under the law.
Right.
That way, again, for me, for my associations, I try to do my amendments.
I'm going to wrap up this question because we have a lot more. But what I would say, a lot more. What I would say to this particular person is that the best thing that you can do is read your association documents. If you have questions, feel free to reach out to Lindsay or I. We're happy to help you and guide you if that is something that should be looked at for changes. The builder just turned over the HOA in the past year. We are coming up on a yearly meeting to vote on a new board. Can this board require all candidates to go through a background check by a vote of the present board without changing documents? Based upon my research, no documents cover this topic. Thanks.
All right, so they turned over already?
They're turned over this year, and now they would like to run a background check.
Essentially what they're asking is, can we require board members to go through a background check in order for them to be eligible candidates?
Correct.
No.
Yep. Can you lease common grounds to first floor residents for small patios?
Depends. But again, I assume you're talking about a condo.
Correct.
If you're talking about a condo, you get into taking the common element and changing its use. So one, that would most likely fall into material alteration, which typically requires a 75% unit owner vote. But even if it wasn't considered a material alteration, you're changing the proportion of the common elements, because essentially you're turning that into a limited common element of a unit that one person would have exclusive use for. That requires a 100% unit owner vote.
Okay. As an association attorney, what would you do when the association and their board want to amend the documents in a way that will cause issue, even though it may be compliant with Florida statutes and governing documents? There's a clarification. Many boards want to enact rules or amendments that could open up the door to fair housing or equal credit legislation complaints. I'm going to preface this question. Lindsay is not an attorney that agrees with boards that want to violate the association documents or the Florida state statutes. So just with prefacing that, Lindsay probably would have a meeting with all the board members, letting them know that they cannot act in this manner, and she'd follow it up with an email to CYA on that. Lindsay, you're welcome to add anything you want to that.
You're probably right. I think it depends on what it is. Sometimes there's a gray line. Sometimes it's just something that I know you cannot do. It also depends, I shouldn't say it depends on what my relationship with the board is. Let me first say that if I see you trying to do something that I don't think you're going to do, that you shouldn't do, I'm going to tell you that. Now, who I tell is going to depend on who my communication with. If my relationship is with the president, I'm probably going to start with a phone call. Because I might not want to put that in writing, because ultimately I may say to the board, listen, maybe you don't want my opinion on this. And if you don't want my opinion, then I suggest you not get it from me in writing, but let me just tell you. Now, if they insist I draft it, then I probably will do a CYA, so that I obviously also protect myself, so that someone can't come back later and say, why did you draft this knowing? If it's something that's going to get me in trouble, as if I'm not being ethical, I won't do it at all. But I've seen a lot of times where I'll be doing amendments to documents, and I will see in a document something that says children under 10 years old can't use the gym without an adult, or you can't swim in the pool. Now, common sense says, well, what would be wrong with that? Like, that's safety. Like, clearly, a kid who's like 2 years old shouldn't be swimming in the pool by themselves. Well, fair housing doesn't look at it that way. Fair housing looks at that being age discrimination, possibly familial discrimination. In my opinion, to some extent, I think that that is dumb because it's a safety issue. But unfortunately, that's not how fair housing looks at it. So if I see that in your documents, I'll probably point out to you, like, listen, I'm not telling you you have to change this, but you need to know that having this in there, if someone brought a claim against the association, fair housing would probably run with this. You should change this language so it says anyone who's not capable of swimming on their own is not allowed to be in the pool. And because listen, what if you have some 2-year-old that just, there are 2-year-olds out there that can swim. And as far as the fair housing is concerned, why should you regulate that? It's the parent's responsibility.
So Lindsay,
yeah,
I'm going to move on now.
Okay.
Is there a way to institute a $300 fine, perhaps fee or damage assessment for someone that hits a community gate if the document says $100 fine per day up to $1,000 when this is a one-time incident, or must you charge $100 a day language even this is not per day incident?
I wouldn't do it as a fine. I would do it as damages
or a fee, but you have to make sure that it's
damages. I mean, you want to charge them what it costs to fix the gate,
right? But you have to make sure that you have to make sure you have a sign at the front at the gate saying that there will be a charge for damages.
I mean, most declarations say that if someone's conduct or negligence damages property, they're responsible for the damage. Now, whether you charge that to a guest or whether you charge that to the owner, whether you have a sign up front or not is not gonna alleviate the owner's responsibility. If you have a guest that comes through that gate and they damage the gate and you're the owner, you're responsible for it. So I would say I don't think you would so first of all, no, you can't decide to increase the fine from 100 to 300. You can still do 100 and it's not a continuing violation. So it would be a one-time $100 fine. But I don't think that that's going to get you what you need. What you would do is you would look at the association's documents to see if the association has the right to pass on the cost of the damage. And I would tell you that the likelihood is the documents do. So you would charge the owner for what you'd submit the invoice and charge them for the owner of the gate. Now, what you need to hope is that your documents say that if not paid, you can treat it as an assessment. That's the key. If they don't pay that damage, is it just a lawsuit against them, or can you file a lien and foreclose on them? And that's going to depend on your association's documents.
Okay. Thank you. You ready for a lot more?
Okay.
When we issued a fine first, owner has not been reminded of the issue, and property manager only issued a one-time $100 fine. Are you saying that we could charge $100 a day until remediated or reach $1,000 cap?
I mean, it's $1,000 cap for a continuing violation, but that doesn't mean that under certain circumstances, the violation might not start over again. You and I have actually had this with a hose in a neighborhood where the person kept refusing to bring in the hose, brought it in for a day and then left it out there again for another month.
Please don't remind me.
We were capped at $1,000 each incident, but the incident happened again.
Correct.
Now,
when does the fine apply? When the notice goes out, or after the hearing is taking place?
So you're going to have two. First, you have to have a board meeting where the board decides to impose a fine. Okay, so that's just a regular board meeting. Then you have your committee meeting. You cannot levy a fine until the committee either approves or rejects what the board imposed. So you have to give a 14-day mailed notice to that owner, letting them know that there's going to be a hearing, that they're allowed to attend the hearing, and then the committee decides. If the committee approves it, it's due within 5 days. If the committee rejects it, you can't levy it.
Okay. Can you send the amendments to the homeowners with the underlines and strikeouts for the vote, but file the reinstated version instead?
If it's an amended and restated, you can file it clean. If it's a just regular amendments, no, it would still have the underlines and the crossouts.
Okay. We have our association documents revitalized 2 years ago with a lawyer. If we change one of our rules and regulations now, how do we record it? Do we need a lawyer, or can the board do it on its own?
You always need a lawyer. Anytime you're changing your documents, whether it's a rule, declaration, bylaws, that is the practice of law. You are not allowed to just draft rules and impose them.
Okay. We just wanted to strengthen our rental portion of our docs, but it sounds like it could cost us more than $1,000. One of the questions, it actually kind of relates. One is, what is the average cost of an amendment? And then the other one was, what will the cost be for a rental restriction amendment?
I mean, it depends, because it all comes down to time, right? If your association's documents have 3 pages of, like, if the section that's being amended is 3 pages, is 5 pages, I do not like doing amendments that are choppy. There is nothing, and I'm sure that most of you can agree with this, there is nothing that drives me more crazy. That I probably should be careful how I say this, because I also don't want to offend anyone. But I think that when a lawyer drafts an amendment and does it choppy, where you have to look through 7 different amendments over all these years, and you can't even read the full context of what that amendment is in, to me, that drives me crazy. I think it's sloppy, and I think it's lazy. When I do it now, if that's how the board wants me to do it, I'm happy to do it that way. But that's not what I recommend. I recommend whatever article or section it's in, you have the full section with the amendment, so that when you read it, you don't have to flip between 10 different documents to see what it says. So some of the cost just depends on, are you changing one line? Are you changing everything? I mean, listen, I've had some really short amendments that were a very short paragraph. It was an hour of my time. But then by the time you're done with the notice, I mean, I tell you that I think the least expensive amendment you're probably doing is $500. Okay? Because you're looking at about 2 hours of time. By the time you're done with the emails to the attorney thinking about what to draft, sending it to you, and then preparing the notice and preparing the proxy, I think you're looking at probably 2 hours of time. Can it be less? Yes. I think on average for a rental restriction, it depends on how much is being changed. Like, am I amending something that's already there? Am I coming up with something that's completely new? You're probably looking at about maybe $1,000 for everything, but it depends. I mean, I hate quoting in advance amendments, because until I see the section and know what the work is, it's hard to know.
Right.
Oh, and by the way, I could have a board that takes exactly what I send and they say, I love it. Or I could have a board where we go back and forth 10 times on it. And so that impacts cost.
So Lindsay, if we want to add transfer fees to the HOA when a property is sold, does that have to go into the governing documents, or can it just be in a memo?
Well, that's the same thing.
Right.
Like, what do you mean? You mean, can you do it in a rule?
Right. So do they need to add a rule, including a transfer fee? I think the answer to that is that documents have to allow.
You can't create a transfer fee by rule. It should either go in your declaration, or I believe I've seen it in bylaws too, under the authority and power section. Well, it'll say that the association has the right to charge a transfer fee. I would probably, you could do it there, as long as there's nothing in the declaration that prohibits you from charging transfer fees. So you've got to make sure there's no conflict. But again, that might depend on what's in your declaration. But if your declaration already has, like, an application process, and it says the association is allowed to make rules and regulations regarding, the application process, then I'd say you probably could do that in a rule. It's still called an amendment, though. Anytime you're changing wording, it's an amendment, whether it's to the declaration or the rules, they're all amendments.
So on November 1st, 2013, this association passed an amendment to the bylaws, changing the membership vote to amend the bylaws from 75% vote of quorum to an absolute majority of the total voting interest, taken either at a membership meeting or by written consent without meetings to a board initiated proposal. There's no question there. Please, there's no question there. So if you'd like to ask again, I'm happy to.
You can do an amendment like that. I think what you said is originally the vote was 75%.
Correct.
If they're changing the vote requirement, they need the 75% to change it to a majority. Then going forward, you would have the majority vote, but you still have to have the 75% to change it to begin with. I see nothing wrong with it being in a membership meeting or written agreement outside of a meeting. That's very similar to what I was talking to in the beginning, where you send it out by mail. You would still typically need the same vote requirement. So if it was a supermajority, you'd still need a supermajority. It just doesn't require you to hold a meeting.
Now, let's say a homeowner is in violation of something within the community, and then he tries to get that rule changed. Can that amendment take place when he's in violation?
So you have a board member.
No, a homeowner.
All right, say it to me one more time.
You have a homeowner that's in violation. They have a pickup truck. They're not permitted a pickup truck. And now he's trying to get that amendment changed. Is that permitted?
I mean, the owner has no right it's up to the board if the board wants to propose amendments. I mean, there may be something in the documents that say that if you have a certain percentage of owners that ask you to put something on an agenda, that you have to put it on the agenda. But at the end of the day, it's up to the board if the board wants to propose to the owners an amendment regarding trucks.
Right.
I would say that changes if what you were saying to me was it was a board member in violation and the board members proposing to the board. I would probably tell that person, you have a conflict here. You need to abstain from this vote. You are currently in violation. You should stay far away from this. Let the board decide, the other members decide if they want to put this to vote or not. But until there's a change, you're in violation.
Okay. So we're having a problem getting members to volunteer for a finding committee. Any suggestions as to other remedies regarding violations? Go ahead.
Did you have something else you wanted to say?
No, I was just going to say, really, that also pertains to your association documents of what it allows. So if your documents allow remedial work, then maybe you could do a remedial work. A lot of our associations that are silent in any other way, we do a standard, you fix the violation or you go to the attorney and then the attorney writes a letter and then we take it that way. But the remedial work, you have to make sure that there's money in the association's budget that they can allow for the remedial work to take place.
I don't disagree with that. I find that a lot of boards don't really understand what all their options are. They think that it's just fining. I actually think fining is one of, especially if you're in a condo, it's a very weak mechanism. And I differentiate between a condo and HOAs because in a condo, if they don't pay it, other than if they're more than 90 days in paying it, which actually that has just changed too in the new statute. But it used to be that you weren't eligible to sit on the board if you had any monetary money owed to the association. I believe it was just changed now that it's just assessments. Right. But if someone's more than 90 days, you can suspend their right to use certain common elements. You can suspend their voting rights. In an HOA, if you have a fine and their documents allow the fines to become liens, well, then that's a pretty strong mechanism because now you have a lien against the property and you can potentially foreclose. It's very common in associations that neighbors don't want to fine their neighbors. It's confrontational. It's very hard to put these communities together, and you certainly can't. There's nothing you can do. I mean, you could try to encourage it. Certainly, if you have people that are coming to meetings and complaining often, those are the perfect people to put on a committee so that they can see how much work really goes into all of this. But if you don't have a finding committee, and even if you do have a finding committee, there are a few different ways that you can enforce the documents. One, like Jill said, if management has sent a violation letter and no one is complying with it, then you can send it to your attorney for a violation letter. The next question always is, can we charge the attorney's fees to the owner? That depends. If your documents allow the association to impose enforcement costs against an owner, regardless of whether there's litigation, then the answer may be yes. If the documents say that only prevailing parties are entitled to attorney's fees, then the answer is no. You would actually have to file a complaint or an arbitration and be declared the prevailing party in order to be able to pass those fees on. Another option is an injunction. We do them all the time. If you have an owner who refuses to move their commercial vehicle, the documents are very clear, and the association has been consistently enforcing those violations, then we file an injunction and we ask the judge to force the person to move their car. If you prevail, you can pass on the attorney's fees to the owner. And then the third type of remedy is what we call a self-help remedy, which is like what Jill just, which you could have, which is, I apologize, my phone was just ringing. Your documents might say that if someone has installed something on their property or altered their property or has a certain kind, like didn't maintain their property, hasn't been maintaining the roof, whatever it is, that the association has an easement and is allowed to go on the property, is allowed to fix it and then pass those costs on to that owner. So if you have something like that, you could go onto the property and fix it. If someone damaged the common elements, you're always allowed to fix that and charge the owner because they've damaged the property, especially if they were negligent. So again, all of these require you to look at the documents. You should not be making any decisions under any circumstances without pulling the documents first. Every association is different, and your declaration guides you and what you are or are not allowed to do. And the board only has the authority that's in the documents.
So in rules and regulation documents, can you use the word shall when it comes to a rule regarding applicant's age, for example, versus recommend if there is no mention of this in the association documents?
Well, I don't see what the point would be to recommend. The whole reason you would have something in there would be because you want someone to comply with it. You could give all the recommendations you want. If it's not a requirement, no one's required to do it. Typically, you know, you can't do anything with an applicant that's under 18 years of age. Like you can only run a background check and a credit check, you know, people who are 18 years and older.
Okay, so the amendment passed by 11-1 vote out of 16 total membership. It was prepared by a lawyer and we cannot find any error in the procedure, but it was not recorded. We found out on July 1st, 2018, the state passed required recording of all rules and regulations, but not ex post facto. Is this amendment good?
Is it an amendment to the rules?
To the rules.
And it was before the requirement that the rules be recorded?
Yes.
Yes, that's probably fine because typically amendments are not retroactive, they're proactive. So if you did the amendment after the statute was changed to require that they be recorded, then I would tell you, no, it's not. If it was prior to, then yes. I'm not aware of anything that required that associations take all their current rules and record them.
Right.
Which obviously, though, if you think about it, it would have made sense to do
Lindsay,
that.
we have a ton of questions here. I'm just going to go through. I'm sorry to all the attendees, but I'm going to go through the ones that apply to amendments. What doesn't apply to amendments, we can answer them separately. You can email either Lindsay or I, and we'll be happy to answer them for you.
I'm so happy that everyone's so interested. I think that's a good sign
for our sexy conversation here. If our association recently, within the past 4 months, defeated a proposed major revision of our documents, what can be done to prevent the board from putting it back up for an owner vote, rather an expensive venture this fall? The attorney is pushing for such action and we are far over budget with the legal expenses now. The problem seems to be that all changes were lumped together and the owners voted no if they disagreed with the single item included in the revision. Well,
okay, wait. So the question is what?
So they lumped all the,
it was a yes
everything
or no.
Together, right?
Yes was a vote for all, and you know, and I always ask my associations, how do you want to vote on this? Do you want me to break it out per section? Do you want to doing it by sentence doesn't really, make sense, because if one thing doesn't pass, it can affect, it all depends on what it affects. But if things are totally separate, let's say you're just doing like 4 or 5 amendments, I always have people vote on that separately, unless the board insists otherwise. Unfortunately, if it didn't pass, your only choice is to put it to vote again. And you can either take out the things that you know that people were not willing to vote yes on and either remove it or break it out for a separate vote. That's probably when I would have a meeting with the owners to find out why did they vote no. But if budget is your problem and you don't have the money to do it, you might not have the money to do it.
Right. Now, what if the condo has common elements and private units? Can the whole facility be made into a non-smoking facility, or is it limited into common areas?
I have done that. I have done full non-smoking, including in units. I think the question becomes, you need a unit owner vote for that. If I was an owner that smoked, I'd probably be pretty upset, but I'm not aware of anything that says that particular owner has to vote yes on it. Smoking are pretty big nuisance issues. They're actually surprisingly trespass issues, because the smoke can get through cracks in the wall and affect units in neighboring properties. But it's a vote, just like anything else. You're going to have to amend the declaration. Now, if you want to make your common elements non-smoking, you could do that in a rule, okay? Because it's common elements, remember. But once you start getting into inside the unit, that has to be done in an amendment to your restrictive covenants, your declaration.
Perfect.
So that would require a unit owner vote.
Okay, so Lindsay, how far after the vote is done and passes does it have to be, does the owners have to receive a copy of it?
The HOAs just require, I think it's like within 30 days, you have to put them on notice it's available. If you're not that big of an HOA, I would say just email it or mail it to them anyway. I don't think the condo statute has a time period, but I would tell you from a common sense approach, you can't expect someone to follow something if you haven't given it to them.
Okay.
So I would send it out I would send it out within 30 days.
Okay, so let's look here for if the current documents do not contain a specific fining schedule, what is the max that can be imposed for multiple violations?
Say that one more time.
If the documents are silent about fining, what is the maximum that could be fined?
You're always can't go more than the statute. You're restricted to $100 a day. You can never, if your documents are silent, you have to look at the statute to see if the statute kicks in and allows you to impose fines. But you always have to stay within the monetary restrictions of the statute.
Okay. Our attorney has billed us in excess of $20,000, but refuses to disclose the owners the exact changes in the revised documents, which have yet to be approved by the owners. Owners soundly defeated this proposed revision. His fees for the project are mixed among other charges, so it's difficult to tend out what the revision. How might the owners depend what the legal fees paid document revisions are to date?
The owners want to know?
Yeah.
Or the board?
Owners.
A lot of times invoices have attorney-client privilege information in there. So, if the attorney, if there's like, first of all, you're not entitled to the association's record. The attorney's records. You're entitled to the association's records to the extent it's not one of the excluded. So the association would probably have to send those invoices to the attorney to redact, or send an email asking, what's the total amount that you've spent on on this project. But is that the question? Is how they can find out what the amounts are?
Yeah.
If the attorney bundled it with a bunch of other stuff, it may be difficult to get the exact number. If you're the association and that's something you know is going to be an issue, I mean, you shouldn't have to do this, but I mean, I like to do an amendment file. I just set up a new file number that's just the amendment so that the association can keep track of what they've spent on the amendment. I don't bill that to a general file. But again, if the association has invoices and there's any attorney-client privilege information, they need to redact what the wording is and then get the just the amount. But depending on what's redacted, you might not be able to tell which is which. I'd probably ask the attorney if they could come up with a lump sum number.
Okay. Changing boards can undo rules and regulations implemented by previous board. To avoid this from occurring, can a board through the attorney move the rules and move the rules and regulations by the bylaws, which are more difficult to change and is more pertinent?
Okay. So if what you're trying to do is come up with a restriction that a board cannot just come through and change, and it has to go through the unit owner vote process, I would make that change to the declaration and send it to the rules. I don't care if you want to have it duplicated in the rules, because most rules, with the exception of common area stuff, is kind of like a duplicate of what's in your use restrictions in your declaration. But if you really have something that you don't want any future boards to be able to change without the unit owners approving it, then you do an amendment to the declaration or an amendment to the bylaws, and you don't call it a rule or regulation. So like example, I might be able to do factors of disapproving sales or leases in a rule, but I tell my clients, if you really want to make sure that another board doesn't come in and change this, you do it in the declaration and let the owners vote on it. Your declaration is always more enforceable than your rules. There's always enforcement issues with rules.
Okay. So when the board doesn't, when the board does not enforce the rules and regulations, how can they reinforce them?
Okay, that's a really good question.
It is.
So, sorry, I didn't say that about all the questions have been good. Okay, this is a really good one though. So if the board has not been uniformly and consistently enforcing either the restrictive covenants or the rules, you have to jumpstart your rules again. Okay. So again, I always like to use trucks, for example, or pets, something like that. If you know that you've had owners that have had trucks in violation of the documents for the last year in your community, but you have a board now that wants to say you're not allowed to have trucks. And again, this is just a very broad example. You cannot a year later say you have to remove your truck. Okay. You're probably going to have to grandfather in those people who violated and then send out a notice to everyone, letting them know that as of this date, this is a restriction. We want to remind you what it is, and we're going to be enforcing it as of this date going forward. And then you have a whole grandfathering in process. You know, like you're going to have to kind of walk around the property, see who has commercial vehicles. Some people might buy some commercial vehicles within this time period. But essentially, you have to put everybody on notice in writing that these are the restrictions and that you're going to be enforcing them. And then you have to enforce them. And essentially that jump starts your documents again. Now, there's no specific way that you have to put them on notice. It can be a note card. It can be sending a copy of the rules just with a cover letter, reminding people. If you're an association that does newsletters, it's something that you can do through a newsletter. But you do, you know, if you haven't been enforcing your documents, you can't just decide 3 years later you're going to enforce it without giving people a heads up.
So we have finished with all of our questions. There's a lot of really great questions. I do want to thank everybody. If we have not been able to get to your questions, you received a response from me just saying to please email Lindsay and/or I, and we'll be happy to go through how we can help you on your next steps or whatever questions that you might have individually. But we really appreciate the time that you guys have spent with us this morning. And who would have thought that rules and regulations and association documents were as sexy as they turned out to be? But I do appreciate all of you taking the time. Lindsay and I do have another another group coming out in the next couple of weeks, and Sebastian will be in touch with all of you if you want to join on that as well. Lindsay and I like to call it like more of like a coffee talk versus just a seminar. So we really appreciate you guys joining us.
Yes, and thank you. Thank you for the opportunity. And I appreciate all of you coming out on a Monday and listening. And if I can be of any help to your associations, you know, I don't know who's property managers or owners or board members, or if you're not happy with your legal counsel or you just want a second opinion, please reach out to me. I'd love the opportunity to talk to you. I'm sure you can tell I love what I do. You can ask anyone who works for Jill. I have very good relationships with the managers that I work with. They know they can call me at 10 o'clock at night and reach me. They all have my cell phone number. My board members have my cell phone numbers. I'm really, really passionate about what I do, and I love to help people. So if there's anything I can do, please let me know.
Perfect. Thank you to everyone for coming out today. On behalf of course, of Vesta and Lindsay Raphael, we thank you as well, and we hope you'll see us for our next webinar. Just so you know, everyone that attended today will be receiving a copy of our presentation and a recording, and it will be available on our website 24 to 48 hours after today. Thank you again, and I hope you all have a great morning.
Thank you.
Thank you.